This is case numbers 2007-0566 and 2007-0685. Douglas Lambert et al. Versus Belknap County Convention.
Counsel, before you begin, Judge Galway is disqualified. In this case, you may proceed.
Thank you, Your Honor. Coming here is an experience, and I was trying to think just what I could say that hasn't been written or submitted to the court in briefs.
You don't have to say anything if you don't want to.
Yeah, but it's not my nature to say.
Well, then go ahead. Start.
That doesn't make you unique, by the way.
Thank you. That helps a lot. There's a lot of things I wanted to say, and one thing that came to mind was, why are we here? Because the evidence is the evidence, the facts, the minutes, all that's been submitted won't change. We aren't arguing our case on opinion. We believe we're citing the law and some case history. So I said, why am I here? And the answer was in the court's order of 17 July. And I quote from page 4, where the court stated, the convention is entitled to hire public employees, including the hiring of an interim sheriff. And the fact is that the county convention, or delegation, however you want to apply the term, is not empowered in any way, shape, or form to hire any employees, not one. That responsibility falls to the commissioners, but not the convention, to the department heads. And one of the other things that came to mind is that with regard to the sheriff, the constitutional officer, there is case law that says that the county convention has zero authority other than appropriation, like it has for all the other departments within a county. So if there's nothing in the Constitution or the law that empowers the convention to hire people, it was employees. They were never hiring an employee. They were filling an office that was vacated by a constitutional officer. There is no relationship between employee, employer when it comes to the county convention, or in fact the voters. A constitutional officer, the sheriff in this case, whether it be appointed or elected, once that takes place, there is no longer any jurisdiction by the voters or by the appointers. They can only be removed from office for misconduct and by the courts.
So what are you saying should have happened in this case?
In this case, as we presented, in this case, the court heard in many points, and specifically that they cannot hire any employees, and the sheriff, at the time, we sought an injunctive relief. It was denied. We appealed. It was denied. The sheriff should have not been able to take his oath of office.
Why not?
Because he wasn't duly elected, duly appointed in accordance with the right to know. The convention violated the right to know at every turn, and it was a remedy because they violated the right to know.
Why is that the proper remedy? The trial court considered that as a remedy and said no useful purpose would be served, even if there were a right to know violation.
The useful purpose would have been they would have had to go through the process. There was no urgency, no urgency whatsoever. The acting sheriff could have continued on for months if it had to do that. All that the court had to order for remedy is that the process be redone. And they
in what fashion? In the open, you're saying?
In the open.
Let me ask you this question. It's off the subject, but you present a number of issues. Prior to this procedure, it's my understanding that in the olden days, such sheriffs were selected by judges, maybe Superior Court judges. Let's assume I'm correct in that memory. Would you have the meeting that took place among the Superior Court judges required to comply, to select that interim sheriff, comply with the right to know law? I mean, that's how much your argument hits home.
Okay. I believe that as a voter, had I wanted to, I could have gone into the courtroom. I don't believe it was done in judges' chambers. I wasn't there. And in spite of my age, I didn't have a great interest in government. So, but my view is that because it was done by the courts. It was not a court proceeding, it was just done by an officer of the court, a judge. So I could have been in the courtroom when they interviewed any one of the applicants who wanted to be nominated for that position, and observed the entire process. Apparently, the legislature thought that I tried to look up the legislative intent, and I got as far as the state library. And the only reason that they amended the law that took the authority away from the judge, a judge, was to make it better. Well, the only way that it makes it better, in my view, is that it becomes an open process where anybody can observe, and it's not a one-person decision, it's the convention, 18 people.
Can I ask you something, because maybe I misheard you, and it confused me a bit. I thought you said that the county convention did not have authority to hire an interim sheriff that belonged to the commissioners.
No, they don't hire a sheriff, they appoint an interim sheriff.
Is your contest here that they don't have the authority to do what they did, or they have the authority, they just have to do it more publicly?
They have the authority to appoint an officer to fill the vacancy of the office.
But they have to do it more publicly.
They have to do the entire process in public.
What about the issue relating to the applicant's personal information? You seem to think that that should be part of something that the citizens should be able to take a look at, but I think there are some exceptions in the statute for private information.
If your contention were in fact correct, and assuming that to be correct, then people running for office, elected office, a constitutional office, would not have to say who they were, where they're from, how long they live in the state, or anything else. They'd be an invisible person. And we, the voters and the citizens of the state, would wake up one morning and find that Tom Tardif has just been appointed sheriff.
So no
Where
part
did he
of
come
it?
from?
No,
What does he know?
no part can be done in private? No part of the selection of a constitutional officer should be done in private?
Should not be done in private.
Okay, same rule for appointment of judges?
It wasn't always that way, Your Honor, but about 10 years ago, an individual, moi, went and wrote a letter to the Executive Council. And the Executive Councilors used to query the individual applicants for a judgeship. I don't know about Supreme Court judge, but
Oh, yeah, they do.
lower
Don't
court
worry,
judge.
they do.
And you'd all get lobbied by the Executive Councilors. And I think it was Attorney General McLaughlin at the time, or maybe somebody else, I lost track. And they revamped, and now they have a hearing for appointments to the judgeship amongst all of the executive counselors, so that all the
But they
executive
don't,
counselors...
but today, people who apply for judgeships don't all have a public hearing, do they? The governor narrows it down to one person, and that person has a public hearing. But I don't think anyone else is subjected to a public hearing or their personal information disseminated, is it?
To my knowledge, to my recollection, and it's been a while, and I'll admit that, I'll address Councilor Burton has on many occasions stated there was a hearing for interviewing the applicants for a judgeship. I wasn't prepared to support that, but that's my belief. I don't know about Supreme Court justices. I openly admit that. I'm only talking about Superior Court.
Well, the
District
governor now has a commission, and he appoints the members of the commission, I believe, and people who want to apply to the commission initially and provide a lot of personal information. They recommend 1, 2, 3, or more names. The governor meets with them. He decides on one. That person has a public hearing. My understanding is everyone else does not.
But also, you're not elected. You are totally appointed by your peers more often than not, I think. But these constitutional officers and other elected officials, they're elected officials. So the public has full knowledge of the people that are going to represent them. And they need the same full knowledge of people that are going to fill these positions, these offices. There are no, time's going to run out, there are no elected officials who will ever get unemployment. Never. They don't get critiqued, they don't have performance reviews, their salaries are set, that's the way it is.
But the sheriff who's appointed on an interim basis has to stand for election.
Well, the court didn't agree. The court ruled against that it wasn't an election.
No.
Next time around.
The next time around, they're on the ballot, so everyone gets a chance to hold them up to the bright bulb, don't they?
That may be. That is a fact. It's not maybe. That is a fact. They're either going to get reelected or not, and that's the only time that the employers, all of us voters, have a say.
So
But we know everything there is about them. Whereas in this case, I didn't know who Sheriff Wiggins, Mr. Wiggins was before he was the sheriff, or any of the other 7 applicants. No one has ever objected to us looking at the resumes. There's no affidavit that's ever been submitted that says, we don't want you to know where we're from, what our qualifications are. I know from a county perspective, a county prosecutor runs for office, and all they need to do is say, I'm going to live in that ward so far in the state. All they got to do is say, I will live in that county if they're elected. And that makes them eligible.
Let me ask you this. Were the final 2 candidates interviewed publicly?
For a second round.
Yes. That was done publicly.
The second round was.
Okay. Would it be your sense that the law would require that if they get 10 applications, for example, any discussion about those applications must take place in public session? Anyone they consider, they have to interview publicly. That would be a 91A result that you would say is required.
I would say it's required. And further, the fact is, all the discussions they had in non-public session, there are no minutes. There are no minutes, and we can't review the records, and none of the records have been sealed. A sealed record, from my personal experience, goes in a manila envelope, and it's sealed. In the recording secretary, the clerk, no one has access to that until the body, public body, releases it, unseals it. In this case, all of the records that we sought after in part 2 of the case, they were never sealed. The clerk had access. She received them as open letters. They stayed as open letters, and she unilaterally just says you can't have them.
I'm going to have to interrupt you because your red light is on.
Oh, sorry. Excuse me.
For someone who wasn't sure whether they should argue, you did a good job.
Thank you very much. An honor.
Thank you.
Good morning, Your Honors. May it please the Court, my name is Daniel Mullen from Ransomar Spellman, and I appear on behalf of the Belknap County Convention, Representative Stephen Netto, who was the chair of that convention, and Angela Bell, who was the records keeper. I believe the Court has addressed the two issues in this case. First is whether or not the appointment of Sheriff Wiggins should be invalidated as a result of violations that occurred under 91A. The second issue is whether or not the applications of all of the candidates that applied for this appointment should be disclosed to the public. Feel free to ask any questions.
Well, answer those 2 questions.
It seemed to me the argument here was that not only did they not state the exception, which the trial court said they didn't, but that the exception the trial court said they should have stated doesn't apply to constitutional officers. It applies to public employees, personnel issues, and they seem to be arguing, well, it doesn't apply for a constitutional officer.
I agree. I think that, and we disagree with that. First of all, and I think that goes more to the applications than it does to the, I think that Judge Moll analogized whether or not the appointment should be invalidated by referring to RSA 91A3, but I think he could have not even cited that statute in determining whether or not the appointment should be invalidated. I think he was just using that as a basis of trying to get into the thought process of the convention in doing what they did, and saying under the circumstances of that particular case that he was not going to invalidate it in his discretion, since 91A8 gives him the discretion to invalidate as opposed to making it mandatory, and he was just using it as an example.
You mean 91A3?
91A3 is what Judge Moll was using
Right,
as
but
an analogy.
That says the hiring of any person as a public employee.
That's correct.
This is an appointment.
And I think in this particular case, an appointment is a hiring. I mean,
Well, aren't they different? Hiring is different than appointment.
well, you're appointing someone to a job. You're hiring someone to do a job. I mean,
Right, but they're different words connoting different things. I mean,
and
here-
I think the appointment in this context is that, you know, there is no, the appointment here is because the person doesn't really answer to anybody except the voters. The hiring authority would have the ability to supervise the person hired. So I think,
So it doesn't look much like a hiring.
well, I think it's analogous to a hiring, Your Honor.
maybe analogous, but it's a different word.
It is definitely a different word.
So it has a different meaning. I mean, that's the problem I have. They say hiring here, and this is definitely an appointment.
And I don't think that in the context of 91A, I think hiring has a broader context than.
Why should it? I mean, this is a substitute for an election. It's not like they're hiring someone to, paint the building. They're hiring someone who otherwise would be elected, and if we're going to construe the statute, we should construe it, it seems to me, in favor of openness.
You're appointing someone for a limited period of time until the next election, so that person can decide whether or not to run for re-election or decide not to run for re-election.
But it
Part
may
of it
be,
needs to be open?
Excuse me?
Judge Delanis, go ahead.
but that limited period of time may, in some extreme hypothetical, be an entire term of office. Let's say the sheriff dies the day after the election. So you've got an appointment of a new sheriff for however many years in the various counties the sheriffs are elected for. Why shouldn't the citizens of the county be able to at least take a look at the resumes of the people who now want to spend some time being their sheriffs? I'm sort of not getting that. Because you said a few moments ago the only people that the sheriff is answerable to are the citizens.
Because there's once in office, that's true. I mean, the only way that he could be, I guess, taken out of office would be by some other process similar to impeachment or recall.
Sure. And so let's say all of the people who apply for this job have absolutely no qualification to be sheriff of anything, nothing. And the voters don't get a chance to take a look at the fact that their chief law enforcement officer last worked 20 years ago slinging burgers at Burger King. They might, if they knew that, have a chance to say to the appointing authority before all was said and done, you might want to seek a second round of applicants here. And if they don't get a chance to see it, then pretty soon our erstwhile burger flipper is now running law enforcement.
I understand what you're saying, Your Honor, but the process is as put forth in the statute, and it's similar to what I think you were discussing earlier with the appointment of judges, with appointment of Attorney General, with the appointment of a whole slew of executive officers. The same argument could be made.
No, it's not, because this person is otherwise elected. And so I don't see how it's an invasion of privacy for people who are seeking what is otherwise an elected office to reveal their qualifications for that office.
And I think in this case they were revealed during the public meetings held before they were.
Not everyone who applied.
No, but I think that it's the same as judges. Not everyone who applies to be a
No, but
judge.
everyone who runs for sheriff has to campaign and answer questions from the electorate.
But this person did not run for sheriff.
That's my point. This is a substitute for an election, so shouldn't it have the same kind of openness as an election?
I think in this context, it does not have to have the same kind of openness as that an electoral process would, Your Honor, because they're looking to fill a vacancy in a relatively quick fashion in order to have someone run the office of sheriff until the next election, which is held every 2 years.
What is so private? I guess I'm having trouble with that. What's so private that can't be revealed? I assume that all these people applying wanted the job.
I would
And if
assume,
they got the job, they go to a public interview, and they'd be held up to the bright bulb. So it seems to me they're going into this process with the understanding that they may well be totally exposed on everything they've said, done, or written.
I think that if
That's a little different if you're applying to be just a line worker in some town government, isn't it?
But I think the application process here should be held somewhat private in order to attract as many candidates as possible. There may be some people who, for whatever reason, would not apply if the process were totally public.
Isn't it true, though? That assumes people applying don't want the job. I mean, it seems to me they've already crossed that threshold, which is I'm willing to put myself out there because I want to be sheriff.
Correct.
So they hope to be exposed to the public. So the people who are reluctant aren't putting their applications in, it seems to me.
Correct.
They would back away because they don't want to apply for a job they don't want. So I don't feel that constricted about their privacy. They want the job, which is very public, right?
But in this case, it's an appointment for an interim period of time, and all of these applicants, I assume, had other jobs. Some of the applicants, and I can't speak for them because I don't know who they are, may not have want their current employers to know that they were looking for another job.
Well, it's different when you're going for a constitutional office. You're putting yourself out into the public. You're not just transferring from one law firm to another.
I again analogize it to the appointment for a judge. I mean, the whole process there is until the final candidate is nominated, it is kept basically in the dark. The recommendations made by the Bar Association to the governor, nobody knows until that final candidate is nominated. And I think it's for very similar reasons, is that you want to attract a large pool of candidates, and some people in a law firm who want to be a judge may not want their partners to know, may not want their bosses to know, or whatever, until the final moment when their name is actually placed in nomination.
I'm sure that's true in some cases, but as Justice Duggan said, this is a very public office. It's an elective office. And it seems to me, the sunshine of public knowledge is beneficial. It seems to me like people running for the job, right? And say, well, I don't want to tell you anything about myself. If I don't win, I don't want you to know about me. They say, well, you chose to run. When you file the application for the interim sheriff job, why is that any different in any material way from putting your name on the ballot or putting your name out in public to run publicly for the job?
Because
why is it any different?
I think there may be candidates who may they don't want to run for a public office after the interim period is done. They may just say, I'm going to finish out this unexpired term of the sheriff, and I have no desire to go through the electoral process. I will not.
Maybe they shouldn't try then. I mean, the public, it seems to me, the argument is the public has a right to know who's serving in public office. If they don't want to do that in the way that's intended, maybe they should say, well, I guess I'm not cut out for public service.
Well, going back to what Justice Six started out Mr. Tardif's arguments with, the process prior to the Belknap County Convention or the county convention appointing this was that the Superior Court appointed, I believe they call them commissioners, to perform the office of whatever it was, whether it was the sheriff or the county attorney or whatever. And the process, as far as I knew, was done with the judge looking at the various applicants and doing an interview. And I don't know if it was, I don't think it was public.
Let me ask you about the remedy. Let me ask you about the remedy here. The election was held in secret.
And a judge
and you acknowledge that's a violation of the right
Yes.
to know law. If there's ever a circumstance in which we should set aside an election, shouldn't it be when the election's held in secret?
Yes, and I believe that the judge considered that in deciding whether or not to
And the judge seemed to
invalidate.
think that the outcome would be the same,
The vote was
or not substantially different or something.
right. The
How
vote was 10 to
do we
4.
know?
Well, I think the judge relied on the fact that there was no evidence put before him that the result would be the same.
How do we know? It's a secret.
Well, the number wasn't a secret. It was 10 to 4.
I mean, we know it was
the
10 to 4. We don't know who voted for who.
Correct. We don't know who voted, but we know the outcome was 10 to 4.
It might have been different if the public had known who voted for who.
I guess that's speculation, and Judge Mole, I think, considering all the circumstances in the case, decided that.
Do you think it'd be okay if the governor and council voted in secret on public appointment?
Excuse me?
Would it be okay if the governor and council voted to select an attorney general in secret?
No.
Well, what if we knew after the fact it was 4-1? We say, well, no, that's okay.
I think that the court would have the discretion to invalidate it, which is what Judge Mole had in this case.
But the argument would be the same. Well, there was no evidence that anything would have changed. Well, obviously, because nobody knows what was brokered inside the room that I wasn't allowed into. So if we can't elect the attorney general in secret, why can't we elect the sheriff in secret? I guess that's my problem.
I agree that with the whole proposition that nobody should be elected in secret under 91A. The question is whether or not the remedy requested an invalidation of that election should take place.
But if that's not correct, or if Judge Moll is correct, then there is no remedy for the violation, right?
The remedy is may invalidate under the circumstances of the case.
No, my point is the trial court said, I'm not going to invalidate this secret selection, secret appointment, which would have been the only remedy, so therefore there is no remedy for the violation.
The only remedy in this case is the invalidation. It's either do it over again, take them out of office, or leave them in. And I think that's why the law is written as it is, to give them the discretion, because the circumstances of the case, there was no evidence of bad faith here or anything like that.
Sure, but if it doesn't make any difference, that's all the more reason to do it over and do it in public with people's names on the votes. It's all the more reason. And it's Judge Duggan's point about erring on the side of openness in government.
I understand, and I'm just having a hard time finding where's the abuse of Judge Moll's discretion here, which is what the statute gives him.
I understand that's your best argument.
And given what he said, in the case, I don't believe that there was an abuse of discretion here. My light's been on for a while, unless
that's okay. It only controls you.
That is true. But I'll offer if there are any further questions. I'll be glad to answer.
I do have this question. Because obviously this is a significant issue in trying to get to the right result. How would you ever establish, you're a member of the public who was not allowed in the room when they voted. How would you establish to Judge Moll's satisfaction or some hypothetical judge that discretion should be exercised in terms of openness? I mean, it seems to me when you elect someone to a public office, at that moment, an appointment, and you do it in private, it seems to me to run contrary to everything that we're kind of premised on, which is open government. And when you're putting someone in a constitutional office, it seems to run contrary to everything we think should happen to do it privately. And I'm wondering how the petitioners here could have established prejudice. And if they can't, then you might as well do everything in private, because there's no prejudice. The theory is everyone would vote the same, say the same things, do it the same way. We could shut government down if we did that, couldn't we? At least we could cloak it in privacy.
I understand what you're saying, Your Honor, but
what's
at the same time here, we did have an evidentiary hearing to determine whether or not the actions of the Belknap County Convention should be invalidated in the appointment of Sheriff Wiggins.
I understand, but how would they prove that it should be done over? What would they have to demonstrate? Give me an example of something that you say, well, if that were proven, then they'd have to do it again.
I'm not saying it's easy, but I think they could present evidence that, there was some fraud involved in here.
How would they know? What if...
They know who was appointed.
I'm not accusing anyone with this question, because I have no idea what happened. But in some hypothetical, we're in private, and I'm a member of the convention, and I said, look, this guy's my friend. I really want him to get the job. Here are his family circumstances. He needs it. I know you don't think very highly of him, but I'll make it up to you. Well, say that happens. Mm-hmm. And no one knows about it.
And
it's okay?
And suppose it's in public.
Is that okay?
No.
Then how would someone... let me finish. How would someone not in the room know that that happened?
They wouldn't.
So that's why we have elections in public, don't we? Isn't that the reason we should take the cloak off?
Well, in your hypothetical, though, there would be nothing that would prevent the voter from thinking that, having discussed it in a caucus prior to the public vote, going out and vote, and not just saying, I vote for Craig Wiggin without giving any reason. I mean, that's how votes are done in the legislature in public all the time. I mean, we do not know exactly what the deliberative process necessarily was.
Well, why can't the governor and council then select the next attorney general in private? Well, they're honorable people. Why can't we say we trust you?
I think the vote must be taken in public. The discussions that occur behind closed doors in some form of caucuses, I think that occurs quite frequently. And that is the practice as to kind of a weeding out process, and then they weigh whatever was discussed in that, and then they cast their vote so they're accountable to the public, saying, I voted for this particular Attorney General, and the public can say, well, you shouldn't have voted for that particular Attorney General. There's no reason given when they cast their vote. It's just a vote for or against the individual. And the public is left to suppose why they supported them or voted for them, but it's not, there's no rationale given for the particular vote. It's either yay or nay. And in this particular case, they voted by secret ballot, Craig Wiggin or Mr. Nielsen. They came out in public, it would have been all in favor of, do a roll call. Representative Nato, who do you support?
If you follow your logic, it's not a 91A issue, then why, when I go to the polls in Manchester to vote, does it matter that I'm in a private booth with a drape behind me? Why do I vote in private?
I think you don't, because you have the right not to let anybody know who you voted for.
Right. But if my vote is a decisive vote in a 5-member council, and I'm voting to elect somebody for you, you have a right to see and know that, don't you?
You have a right to see who the person voted for, but not necessarily to get into the thought processes as to why the person voted for that person. And here, I think all Judge Moll saw, he saw a 10-4 vote done by, I assume it was secret paper ballot. He said, okay, they would have gone public. Would have attached a name to the particular 10 votes that would have been there. That's what would have happened in this case if the vote were done in public, period.
Well, that would happen with the governor and council, too.
Yes.
So
it would have been.
They should vote in private. Come out and tell us it was 4-1, and people could attach the vote.
No, and Judge Moll said they shouldn't have done it in private here. I mean,
No, he didn't invalidate it, that's my point.
Correct.
So the council should vote in private, 4-1, have the discussion, they vote, and come out and just explain who was the 4 and who was the 1. That's all we need to know.
I think in the second scenario it would be a closer question. If they attached, although I wouldn't approve of it, if they attached a name to each of the votes, I think that is a little different question than saying 4 people voted for and we don't know who they were, and one person voted against, we don't know who it was. That's a little different question than the anonymity attached to the 10-4 vote in the secret ballot. But I think I've given my best reasoning for why Judge Moll could have done what he did in not invalidating the actions that were taken by the Belknap County Convention here.
Thank you very much.
Thank you.
Case submitted.